My lords, you might be wondering why I'm standing up.
No, it's because of the email.
It is, and there's also another piece of paper, I hope, on your desk, which is the authority that didn't find its way, I'm afraid, into the bundles, the public contracts.
Yes, thank you very much.
So you have that.
I've got that.
But the email hopefully reached you by email, but we've also given you hard copies.
Yes, so we're looking at
Permission to appeal, which is on page
paragraph 10 and 11.
10.1, as my learned friend I think fairly pointed out, the consideration point is squarely raised before the judge.
So the way, I mean, of course, there's more than one way of expressing a point without using a particular word, but my understanding of the situation is that consideration did not feature in the argument before the judge as such. In other words, that we haven't seen the skeleton arguments and they're not in our supplemental bundle that were before the judge. But unless you tell us differently and show us, my understanding is that this point emerged with the clarity with which you wish to express it in this email that is preceded only by the exchange between Mr. Legg and the judge in the reply that you took us to earlier on in the transcript. And so I'm not seeking to make any qualitative point about this, just to understand what has happened in the case, and that it really is that a point that was not argued before the judge has been crystallised in the grounds of appeal, and are now you've now given us the argument about it in full clarity.
Subject to this point, I fully accept the word consideration first emerges from the judge in his discussion with Mr. Legg in reply. What I don't accept is that the point as such was not raised beforehand. Now, I don't want to trespass on my learned time, but I showed you in my supplemental skeleton some of the references, including to my skeleton argument below, where the point was put this way: the customer file didn't have contractual effect because it didn't oblige my client or Panasonic to do anything. Now, in my submission, that is the consideration point. I didn't use the word consideration, but that is what it is. That is the concept that was being discussed. And that's how the judge seems to have understood it. But I'm sorry, I don't want to trespass.
No, well, thank you to you and your team and others for producing this over lunch. We've now got a fuller picture. Yes, Miss Legg.
My lord, whilst we're on that point, perhaps I could just say one or two things, because my learned friend suggests that the point was made. In my submission, it was not made before Mr. Justice Carr. And if I could take you to the judgment in tab 9 of the core bundle at paragraph 46. We don't, Your Lordship is correct to say, have the skeleton arguments that were before Mr. Justice Carr in the supplemental bundle, but we do have his summary of the submissions that were before him. And at paragraph, I think it's at 46, I'm just turning there, where he summarises the appellant's arguments, 45, 46. So what the no legal effect point is at paragraph 46. And there are really two sub-points to that at 46. One is that the signature acknowledging receipt did not confirm agreement that the agreement would apply to any subsequent sale. So that's the sort of the signature incorporation point, so to speak. And then the next one is that neither party was obliged to buy or sell any products after Mr. Jones signed the general conditions. Now, that is sort of the, this general document doesn't refer to any specific items point. But it's not said that the general conditions themselves provide no consideration. There's no record of that in the submissions of my learned friend before Mr. Justice Carr. It is right, the supplemental skeleton that my learned friend put in says it is right that it was put that in the evidence and in the submissions on behalf of the appellant that the document does not have legal effect. But that can mean a whole number of different things. It could mean, for example, that the parties didn't intend for the document to have legal effect. It could mean that it's too uncertain to have legal effect. It could mean any manner of different legal arguments that one could come up with. and one might say that lack of consideration could be one of those potential options, but it wasn't identified and wasn't run. And in my submission, it could well be significant, because if it had been squarely put that the document does not give rise to any consideration in evidence at the outset, then it may, for example, have given rise to questions of applicable law. Why does consideration even matter? This document is subject to German law, and in German law, there is no doctrine of consideration. It may be that Panasonic Germany would have wanted to call evidence of German law, for example. So it does matter that the point wasn't put before, and has practical ramifications on this appeal as well. But that's taken me slightly out of my stride. I'll return to that point when looking at the grounds.
Well, you took us in your skirting to Singh and Das.
Yes.
And one of the considerations when considering the point, if we were to conclude that it was not raised below, is whether, if it had been raised below, it would have become the subject of evidence.
Yes, my lord. What I was proposing to do now is return to my discussion of the law. I was going to look very briefly at Tectada and Butler. I'm grateful for my learned friend having taken your lordships through it this morning. So I won't go very long on that, and then chitty on the same point, and then move on to look very briefly at some of the core documents, and then move on to address the grounds. So first of all, if I could take your lordships to the authorities bundle. I don't know if it's helpful to start with Butler or Tectada.
I think probably both of them quickly would be a good idea.
Yes, well, let's start then at the beginning, so to speak, at tab 2 with Butler. Really, the point that I wanted to make here was that one sees at page 13 of the authorities, at internal page 403 at around B, the key point of difference on the facts between the first communication that sought to entrench its terms and conditions and here is that in that case there was no acceptance of that term, whereas in our scenario we have a signed acceptance of the Panasonic terms. So if there had been a signature to that first communication, so to speak, in Butler, it would have been game over in my submission. And then the next point is at 405E. One has to look at the documents, consider the documents as a whole and look at the decisive document. And I would just respectfully adopt the analysis espoused by Lord Justice Coulson this morning. The key document was where there was a signature on the page where TRW crossed no man's land, to adopt that phraseology. And that Butler is an authority that goes against the appellant in this case. Moving on to tech data at authorities tab 7. My learned friend took you to paragraph 1, and he relied particularly on the second sentence, an offer to buy, which is followed by an acknowledgement, which is followed by delivery will, other things being equal, result in the contract on the seller's terms. But the next sentence in my submission is critical. If, however, it's clear that neither party ever intended the seller's terms to apply and always intended the purchaser's terms to apply, it's conceptually possible to arrive at the conclusion that the purchaser's terms are to apply. Now, in my submission, that's precisely what happened here, where you've got an agreement in writing signed up to by both parties that Panasonic's terms will apply to the sales. Then one doesn't fall back on the lack of a written acceptance and just an exchange of documents. Similar point is made at I think paragraphs 6 and 7 make reference to the absence in that case of an overarching contract. And I think my learned friend placed some reliance on the fact that paragraph 6 referred to an obligation, there should be an overarching contract with an obligation to supply particular connectors. But in my submission, that's not necessary. So long as there's an overarching contract, that insofar as supplies are made, they will be governed, and that's not an uncertain or discretionary matter. They will be governed by Panasonic's terms and conditions. Then that overarching contract binds. moving on to 11, paragraph 11, the part I rely on there is the final part of the paragraph. The traditional offer and acceptance analysis must be adopted unless the documents passing between the parties and their conduct show that their common intention was that some other terms were intended to prevail. That's, again, precisely what happened here. My learned friend sought to add at the time of the contract in issue and then made reference to paragraphs 30 and 34, which expressly refer to the time of the contract in issue. In my submission, that adds nothing to the position. It's absolutely right. The relevant time is at the time of the contract. But if you've signed up to terms and there has been no arrangement between the parties to displace those terms, then at the time of the contract, when the supplies are delivered and accepted, then those Panasonic terms apply. Looking at, very briefly, paragraph 21, I think Lord Justice Coulson picked up this point, but this is looking at the issue of whether there's a course of dealing that can displace the ordinary analysis. That doesn't arise here. I'm not relying on a course of dealing to displace the analysis. I'm relying on a clear contractual document.
I mean, tech data was a course of dealing
yes.
case, or at least the judge at first instance had found it was a course of dealing case, but the Court of Appeal took a different view.
Correct. And the Court of Appeal, throughout, as I've already shown your lordships, envisaged the possibility that one could have documentation to express a difference rather than the ordinary battle of the forms analysis. And then if you look at 24, there's a description of the paradigm battle of the forms, and at 25, it says at the second sentence, it always depends on an assessment of what the parties must objectively be taken to have intended. And then 27 over the page. So this is looking at the argument of displacing the battle of the forms analysis where there is a course of dealing. It says, in my judgment, such a conclusion could only be reached if tech data could show that the parties had expressly agreed that these were to be ignored, or if such an agreement was necessarily to be inferred. Now, in my submission is, we're in the first of those camps. There's been an express agreement that the Panasonic terms would apply and displace all others, even those that seek to displace Panasonic's terms. And then paragraphs 34 and 35, similar points made, and one has to look at the surrounding circumstances. And then 39 is the final paragraph of the judgment, which again makes the point that there could be a case where there could be a case in which a court would be entitled to conclude that one of the parties had not intended that printed terms and conditions attached to its acknowledgements would apply, and where parties have said that only these terms and no others apply. This is such a case. So I rely obviously on Tech Data and Butler and say that they support Panasonic's position on this appeal. And if I can quickly now look at a couple of documents, that's where I sort of rest the points in the law. If I can first take you to the key document, which is in the core bundle at tab 12, page 87. And I say that this is this document clearly and precisely demonstrates that Panasonic Germany has the better of the argument that its terms bind. And this is a signed customer file. It's signed at the bottom, and I think this point hasn't yet really emerged, so I'm just going to make it now. It's the signature. If one looks just beneath the signature of Mr. Jones, it makes clear that this is a legally binding signature of the customer. So if one's looking for some further support...
well, at the moment, I mean, we're not trying this case. The issue is whether the judge was entitled to reach the conclusion that he reached. And so piling extra arguments on one way or the other isn't going to influence the matter.
I make the point, my lord, only if it's said and found that this is a question of construction of the document. Here's the document. It's another point that one would have to take into account, but I entirely endorse.
Well, your point is he was entitled to regard this as being a significant document.
And to draw the conclusions he did, yes, ma'am. Of course, I accept.
That raises the interesting question of whether, if it had been stamped, whether that's legally binding, because it's stamped / legally binding signature. Happily, we don't have that issue in this case because it is signed. But yeah, okay.
Yes. So,
I mean, as I understand your general point, consideration's got nothing to do with this. That parties are entitled to agree terms that will apply to them if they are then going to go on and do business with each other. And the question of consideration has nothing to do with the question of whether you agree upon terms that may apply in future in relation to your business dealings. Does consideration have to pass simply because people agree their putative terms of dealing?
I've got a few things to say about that, my lord. Perhaps
yes,
it's best if I save it for round one.
Yes, right. To save it till then.
Right. The next point I was going to make relates to the TRW documents that follow this.
Yes.
But I should just say, to place this in context, the judgment makes the point that a variety of European entities, TRW's entities, entered into these. Your lordships do have those documents. If I could show you them or just give you the references.
But we don't need that because the judge says that in a paragraph that's not the subject of the appeal. 66. The surrounding evidence shows that this was not unusual for TRW companies buying supplies from Panasonic in Germany. And it's 65. That's the second sentence of 65 is the subject of ground 3, but 66 is not the subject of an appeal. So we don't need to look at that. The judge has made those findings on that evidence. Yes,
my lord. I could give you your references if you would like to look at them. Otherwise, I won't.
No, thank you.
All right. So the TRW document, which is over the page. Actually, sorry. Before I depart from this, I should just. I won't spend any time on clauses 1 and 2, but in my submission, they are significant because they record an intention of the parties to be bound by these terms and conditions, insofar as goods are then supplied in due course. And one sees that clearly from clause 2. So long as they are delivered, they are and accepted. Delivery is accepted, then these terms and conditions will apply. Before leaving this document, I should probably just point out, for example, clause 8 as well, which I don't think has been referred to before. This is a clause that says that we, Panasonic, are liable for material defects proven to exist at the time the risk for the goods passes on. And insofar as one is looking for consideration, Panasonic is there committing itself, binding itself to give a warranty, a particular warranty in connection with the goods it will supply, if it supplies them. And there are various terms and conditions here. And what the parties agree is that we commit ourselves now in 2011 to be bound to these terms as and when supplies are ordered and delivered and accepted. And then these terms will apply. And that is, in my section, a good consideration. I'll come back to that later. So the next page, 89, is the ZF TRW order. It's called a blanket order or scheduling agreement. It's not a purchase order. It's been described as a purchase order, but that's not really accurate because it's referring to a particular type of resistor, and it's referring to an agreed price and payment terms, and there's no suggestion that there was that this contains a record of delivery dates or quantities of orders, etc.
What does blanket order mean?
I suppose I don't know the precise answer to that, my lord. My reading of the document is that this is saying here is a reference to pre-agreed prices for these parts, and here are the delivery terms, etc. And the way that purchases were made was through the electronic system, and then so this order doesn't in effect ask Panasonic to do anything. It's just a record of some discussions elsewhere, and it's the electronic system which triggers the delivery of the items and the supply of the items in accordance with the agreed prices and delivery terms, etc. That's the way that the evidence describes the process, particularly that of Miss Smith. And Miss Smith, in her witness statement in paragraph 7, notes that these don't have any record of delivery dates or quantities or orders. That's at supplemental tab 7, page 126.
Sorry, she says what? Just repeat that.
She says, there I can just take your lordship.
No, just repeat what you said. I missed what you said.
That there's no record of delivery dates or quantities or orders in this particular document. Her statement later on goes on to describe the ordering process. I have to dig out the paragraph reference for that because I think it's around paragraph. Just double check. Yeah, it's described. The process starts at 7 and goes on into paragraph 10. It's a description of the ordering process. So those are the core documents relied upon. I think my learned friend at page 93 of the core bundle seeks to rely on the capitals in that document, which say that they intend to oust any other terms and conditions. And my straightforward submission is that can't have any legal effect because it wasn't accepted. There's a document that was accepted, signed, and agreed, and that binds. This does not. Okay, so those are. I'm moving on now to the grounds of appeal. The first ground is the legal effect of the customer file, and I should say the first point is the point that was discussed. But I think in the end, my learned friend accepted was a lesser point, the one about the meaning of the phrase received and acknowledged. And in my submission, the judge was plainly right and certainly was entitled to form the view that that had meaning. The reference there to legally binding that I showed you under the signature may help support that, but I think ultimately the judge formed the view he did and he was entitled to do so. And then moving on then to the consideration discussion. There are two threshold points here. Firstly, the fact that it wasn't addressed before the judge, and I've already addressed your lordships on that point. And then the second is, why is it said that English law should apply at all? And I mentioned earlier that there could have been German law evidence, and this document purports to be subject to German law. And there's no evidence on it, but I'm told that there is no German law doctrine of consideration. And so why should we be looking at this through the lens of English contract law at all? And the question really is, as a matter of European law, when one is looking at jurisdictional questions, is there a clear and agreement in writing? One doesn't get into questions of consideration. If I'm wrong about that, then I have a number of points to make. And first of all is that there was clear consideration in this case. If I could take your lordships, please, to tab 9 of the core bundle to the judgment at paragraph 70. This is the paragraph my learned friend took you to this morning, and particularly over the page at 73, the words in inverted commas. And my learned friend placed emphasis on the beginning of that phrase, I may or may not sell. But in my submission, that misses the crux of it, which comes just after that, which is, if I do, it will be on the following terms. Now, there's nothing discretionary or uncertain or unclear about that. It's what it's saying is, if I purchase from you, it will be on these terms and conditions. And that's clear consideration. If one is applying English law questions of consideration, then it's plainly right. It may be a conditional consideration. If you do X, then this will follow. But that's fairly commonplace in contracts and in contract laws, familiar with it. And I think there's some confusion introduced by this concept of discretionary consideration. And if I could take your lordships to that part of Chitty that my learned friend went to, 4025, which is in the authorities bundle at tab 15. 218, page 218. The essence of the complaint here is that if the consideration itself is entirely at the discretion of one party, then it couldn't amount to good consideration. So here, if, for example, we had a situation where Panasonic says, I may or may not sell to you, but if I do, if you place an order and I do supply the goods, I may or may not be bound by these terms and conditions. I can pick or choose which terms and conditions apply. Then maybe my learned friend would have a point about discretionary consideration. That's not what is being said here. What is being said is that these terms and conditions will apply to the contracts entered into. And if one looks down right at the very bottom of that paragraph, the final sentence, it says that the objection that a promise amounts on the grounds here discussed only to an illusory consideration can be removed if the promise is performed. Such actual performance can constitute consideration even though the person who has rendered it was not legally obliged to render it. Now, it's always been Panasonic's position that there's no obligation in the customer file or the general terms and conditions to supply any particular goods. One has to first receive an order, process the order, supply the goods, and those goods have to be accepted on delivery. And then there's a concluded contract on the terms. And once one gets through that, even if the discretionary consideration issue had any bite, which in my submission it doesn't, but if it did, it would fall away as at the point at which the goods were in any event delivered. In my skeleton argument at paragraph 6.1, I referred to an extract from the transcript where my learned friend referred to the general conditions as an open offer before Mr. Justice Carr, and I think my learned friend may have used the same language before your lordships. An open offer is capable of acceptance, and if it's accepted, is binding. So it appears to be inherent within the suggestion that the general conditions are an open offer, that they constitute good, they include good consideration. All that's required is acceptance, and then there's a binding agreement. Just a couple of thoughts that maybe...
So that, sorry, just so that I understand that. So that's a suggestion that if it was an open offer, then it must take into account that there was good consideration.
Yes, my lord.
Yeah.
An example, I haven't got the authority with me, Carlisle and Carbolic Smoke Board, well-known case, an open offer. It's capable of being binding. Of course, in that case, it's conditional. If one buys the machine, if one uses it, and then contracts influenza, then one can receive the...
What's the mere puff case?
The mere puff case, yes. So it was said if you use this machine, then it's going to protect you against influenza. If it doesn't, we'll pay you, and you can see our sincerity in the matter. We've put £1,000 in the bank, etc., etc. Now,
The original, a copy of the original advertisement sits outside my room on the floor above. I mean, I didn't put it there. It's been there for years.
the actual original.
Yeah, it is the actual advertisement.
That's great.
Yeah.
You can get pictures of it all over the web as well, but it's not quite the same as the real thing. Now that's obviously a conditional consideration. If you purchase it, then it will kick in. You're entitled, and if the various conditions are met, then you are entitled to the consideration that the open offer binds you to. Basic contract law here. And the fact that quantities, price, and items are to be determined doesn't detract from the fact that terms are agreed once these are set. So in my submission, the analogy with the public procurement contracts is helpful. It's simply an analogy. Mr. Justice Card doesn't go any further than to say it's an approximate analogy. And it's, as my Lord Justice Coulson said, I mean, framework agreements, umbrella agreements, all types of commercial contracts. There are so many that would fall into this category that it's not difficult to see why they should be given legal effect. And I give a couple of examples in my skeleton argument as well, which I won't take your lordships through unless you'd like me to.
Just give us the reference.
Yeah. My skeleton argument is at tab 5 of the core bundle.
Yeah.
And the reference is at paragraph 30.2 on page 49 of the core bundle.
Thank you.
It's a reference to Chitty, which I'll just read out the extract of the skeleton. It says, contracts may also be found to have been made subject to the terms of a master agreement, even though that agreement is not referred to in the individual contracts. And the footnote is in Chitty, and also the authorities in the bundle is to Panorama Developments, which is in the bundle. Another analogy, perhaps, may also be helpful, also only approximate, but for example, that if barristers apply to and join the Attorney General's panel of counsel, they are applying for and being appointed to the panel. You agree to certain terms relevant to the work. Most importantly, for example, the rate. If you're on the A panel, B panel, or C panel, there's a particular hourly rate that applies for the work that you do. So unless there's a bespoke agreement separate to those arrangements, that all work subsequently entered into will be at that hourly rate. It's pre-arranged and preset. There's no obligation to accept any work, but if the work is undertaken, it's done at that pre-agreed hourly rate. It can't be the case that there's no binding agreement that that hourly rate would apply. One couldn't turn around later and say, actually, I'd rather charge my commercial rate. It just doesn't work. So that's ground one. Ground two, as I said earlier, there's not really much, if anything, to add to the analysis. If one forms the view, if the court was correct or was entitled to find that the Panasonic terms were binding, but then it would be most unusual then to say that there should be a different analysis as a matter of European law. The same analysis applies. That the actual consent that one is looking for is found in the signature of Mr. Jones on behalf of TRW. That is actual consent. It's crystal clear and it's binding as a result of pretty much every legal system. The temporal gap, as well, as I said earlier, doesn't cause any concern, and as I said, Salotti is no authority for the contrary proposition. I don't think I need to dwell further on ground 2, unless there are any questions. Ground 3 I can also take quite quickly. I've set out my response to that in paragraphs 33 to 36 of my skeleton argument. It may be that this point is not particularly significant in any event, but in my submission, the learned judge is entitled to make the inferences that he made on the basis of the evidential picture before him. It's not in any event said that the inference is wrong, factually wrong. And as to relevance, it may not be of particular importance for relevance, but it certainly does go to context, the context of the agreement was made in, and its meaning. Unless there are any...
So, just so that I'm clear, you say the judge was entitled to make the inference in the second sentence of 65. It is a reasonable inference from the practice of signing. That's what ground 3 I think goes to, and you say that was something that was open to him.
Yes. On the basis of all of the material before him, he was entitled to form that view. And I don't know if it's helpful for your lordships to just have a look at. There's a document in the supplemental bundle that has a whole raft of orders that were placed by different TRW factories, showing very large numbers of supplies that were made in 2016, I think. And that's in the supplemental bundle at tab 6, page 121. It's absolutely tiny. I think we have larger copies available if it would be helpful for you to see it if you're looking at the hard copy and you'd like an A3 version.
121.
Yeah. Would it be helpful to have a larger copy, my lord?
Very possibly.
Again, I'm in the way of thinking that this was all a matter for the judge. It's not at all apparent to me what weight, if anything, he placed upon before all these documents come up to us. Do we really need this?
It may be that your lordships don't consider it to be...
Well, I mean, there's no point in giving us documents that we're not going to read and study, and if we've no business in reading and studying them, then I'm not really sure what the point of this is.
There is a debate between the parties about the relevance of any findings of the judge, as to whether he was entitled to form the view that there was trade done between different TRW entities at different periods of time.
Oh, just a moment, if you would. I think what we're going to do is to kindly say no to those, if you don't mind, and if they become fearfully important when we hear Mr. Kaplan's reply, well, then we might think about it again. But for the moment, I think we'll rest upon what the judge says about it and form our own views as to how important that point really was to him.
Thank you, my lord. And I have nothing further.
No, thank you very much indeed, Mr. Legg. Mr. Kaplan.
My lords, thank you. Starting with that fearfully important document. All I would say, and I'm not going to suggest you read it or that I hand it up, but it just shows a list of parts sold from 2015. So nothing before that.
Sorry, what is this? Something you have handed up?
No, this is the document that my learned friend just referred to, and he offered you copies,
Yes.
saying, well, it shows they've done all sorts of business over the years. It's only from 2015 onwards. I don't suggest you read the document.
No,
I'm
no.
not going to hand anything up in relation to it. Just thought I'd get that out of the way.
Thank you.
My lords, just starting with the scope of the appeal in terms of how one analyses the judge's decision and what the role of this court is. Again, I mean, there's not much point me making my points again. The position is clear from the authorities, but I think my learned friend and I just disagree on whether, indeed, it is correct to characterise my appeal as highlighting what I say are material errors of law.
Yes.
He took you to...
So really, you're agreed on where the line is drawn, and it's a matter for us as to whether you get it over the line or not.
That's right. So I don't think I need to say anything else on that. Now, on the law, I don't have much on this, but my learned friend said a couple of things that I need to address. First of all, he said that CAFA establishes that a plausible evidential basis is a low threshold. I just make the point for your note that in paragraphs 81 and 82 of that decision, the submission that the threshold was low in an Article 25 case was rejected. So that's CAFA. My learned friend then, dealing with the Battle of the Forms cases, said, well, it's not right for me to have said that if TRW fires the last shot, it automatically wins. Just to clarify, I was making a point by reference to the judgment. The judge in paragraph 81 says that even the two purchase orders could, in normal circumstances, have acquired contractual force by standard offer and acceptance analysis. The reason why I lost below was because, as I've said, the learned judge found that there was a signature of the customer file and that was binding. I don't think I need to say anything beyond that on the Battle of the Forms cases. The key battleground, it seems to me, if I may say so, is this question of consideration. First of all, am I allowed to run the point? And secondly, is it a good point? My lord raised the point, well, does it have anything to do with it? Does consideration actually have anything to do with it? And in my
I'm saying that even in English law.
Even in English law. And in my submission, the answer is yes. And the key point is this. If there's no consideration, there is nothing to stop my clients changing their mind. They simply aren't bound to accept Panasonic's terms. They are free to reject them. And that's what I say they did in the purchase orders.
But when does the consideration have to pass?
The consideration has to pass, well, for a binding contract. It has to pass at the moment you say you're bound. If there's no consideration, you're not bound. I'll come on to the point about conditional consideration. But that also raises a timing point, as I'll come on to. If you put forward, I'm not saying it very well, conditional consideration, and before the condition is fulfilled, someone puts a counter-offer forward, then the offer is destroyed. That's what Butler shows. A counter-offer destroys an offer. And until the consideration has passed, you are not bound. You can change your mind. And that really is the key difference between us. Can my client change its mind before the contracts that we're concerned about were entered into? I say yes, he says no. And in my submission, the only way he can get to that answer is by saying, well, there was consideration. So it is, in my submission, a point that, if I'm allowed to raise it, is material and has to be grappled with. The next question is, am I allowed to raise it? Now, in my submission, I don't really want to add much to what I've said, but my learned friend did take you to paragraph 46 of the judgment. I think that fairly summarises or records the two aspects of my submission below, one of which was neither party was obliged to agree either to buy or sell any products after Mr. Jones signed the PIEU general conditions. As I said to you earlier this afternoon, that is the consideration point. And the judge appears to have understood that, because he then debated it in reply, and he posited a form of consideration at paragraph 70 of his judgment. And the only thing I'd add is that in light of what you've now seen in terms of the grounds of appeal that were put to Mr. Justice Kerr, and which he gave permission to appeal on, he doesn't seem to have considered there was any new point or any problem with these grounds of appeal. He gave an unrestricted permission to appeal after having received these submissions, where the consideration point was squarely raised. As I say, I can't take it further than that, but in my submission,
Yes.
It was a point raised below, and it's one that I'm entitled to run now. Now, my learned friend's next point was that, well, Singh and Das says that if you'd raised it below and it might have changed the course of the evidence, an appeal court would be very reluctant to allow you to raise it on appeal. I've said I've raised it below, so that is not a good point in my submission. But beyond that, I would say my learned friend did have every opportunity to put in evidence, including on German law. He had the first word and the last word when it came to the evidence. And his clients knew that my clients were denying the legal effect of the customer file. And if I could just take you to the supplemental bundle to make that good very, very quickly. It's in tab 3, we get my client's response through my instructing solicitors to the evidence and the application that had been filed by Panasonic. On page 41, we get paragraphs 8 and 9, which say, well, as far as we can understand it, the defendant seems to say their terms govern because of the customer file. The significance of that fact and the construction of the document that was signed are matters for legal submission. Well, that's entirely correct. Witness statements are to put forward facts and not argument. But in order that TRW's position is understood, and without limiting any legal arguments that may be made, I should make clear it's denied that the signature of that document, and so on and so forth, created any particular contract of supply, constituting an agreement to the application of PIU's terms and conditions to any particular contract of supply, and so on and so forth. Now, it's important, and there is nothing improper at all about saying, well, issues of construction and law are matters for legal submission. My learned friend's clients well understood that my client was taking a point on the legal effect of the customer file, and you see that illustrated in tab 7. And page 126 at paragraph 5, this is Ms. Smith's statement in reply. I note that paragraph 9 of Mr. Pugh's first witness statement stipulates that the claimant denies the legal effect of the signed customer file. And then I've taken you through the submissions that were made, the judge's reaction, and then the putative grounds of appeal and the decision to grant the appeal. So there can be no suggestion in my submission that any opportunity to put in evidence has been somehow denied, or that the evidence would have been any different had I used the word consideration expressly, like Mr. Pugh used it. The fact is that the application below is my learned friend's application. He had the first and last words on the evidence, and no German law evidence was adduced. And in those circumstances, it's well known that the practice is to apply English law. That's simply what happens, and that's the battleground that the parties chose to fight. So in my submission, even if the consideration point is a new point, and I don't accept that it is, it's a point that I should be allowed to run. There would be no unfairness in that. And as I say, it's a point of pure law. So then, coming on to the substance of the consideration argument, my learned friend relies on a number of points. He anchors himself to some extent in paragraph 70 of the judgment, and the words in quotation marks on page 73. I may or may not sell to you, but if I do, it will be on the following terms, even if you later say otherwise, and we do not contradict you, and so on and so forth. And he says, well, there is consideration there. It's conditional consideration. Now, in my submission, that's wrong. That is wrong. Panasonic does not bind itself to do anything. I accept that if performance follows, performance itself can constitute the provision of consideration. If Panasonic agrees to sell, and agrees to sell on its terms and conditions, its agreement to sell, to provide goods, is something of value in the eye of the law. It's not discretionary, and that would provide consideration. But there's a timing problem here, because that consideration could only ever arise at the moment that a concluded contract of supply came into being.
But why isn't you being accepted into the family of potential purchasers of Panasonic a form of consideration?
Because there's no promise. We're being accepted for consideration. Panasonic says, well, we'll consider.
Well, you're getting past the first threshold.
But then any counterparty could say, well, we'll only negotiate with you if you agree to X, and that would then be binding. It would create a very difficult situation in terms of contractual negotiation.
Yes, I know, but you're submitting that there isn't any consideration.
Yes.
Firstly, you're taking the customer file as if it was a separate transaction. So let's follow you into that for the moment, rather than it being part of a wider series of legal engagements. But even if one was to treat it as being on its own and requiring consideration, both your client and his client are serious players in the business, and his client is accepting you as somebody with whom it will do business.
Well, no.
In general,
it's not saying we will do business with you. If it had said we will supply you for whatever you need,
all right, I'll put it. Somebody who has sufficiently satisfied us that we will consider doing business with you when you put in orders with us.
Yes, and in my submission, that is not
Right. So
consideration.
you're better off than somebody who might not be as reputable as your clients, who want to be supplied with Panasonic parts but may want to make weapons of mass destruction. I don't know, who they won't issue a customer file to.
Well, if there was an obligation placed on Panasonic that could be identified in terms of considering.
I understand that point because you've made it several times about the obligation.
Make a slightly different point.
But the point that I'm making to you is that you have advanced a step by having, we see on the purchase order a unique reference number or something like this, presumably applies to you in Panasonic's world. You've advanced to the point where you are on their system. Now, why is that an advantage?
Because it's not something of value in the eyes of the law, because any ultimate value that my client gets is still at the complete discretion of Panasonic. And that is the principle. That is the definition.
Well, I still don't see why it isn't an advantage to you to become the client and to be within possibility of doing business.
Under any framework contract, you're at the discretion of the person handing out the contract.
Well, before there's a binding contract, you are. Yes.
But if there's a framework agreement that doesn't specify minimum or maximum goods or subcontracts, you're at the discretion of that person.
Yes, but there will be some binding obligations in order for that to be a binding contract.
Yeah, and then we come back to whether or not these were binding obligations.
Indeed.
It's not a question of consideration at all, which may be why it didn't arise in those terms before the judge, or in Mr. Pugh's very helpful statement, which sets out the 4 or 5 points he takes, not one of which is there was no consideration. And particularly not, well, it could have been consideration, but there's a timing problem. That's a matter of pure fact. A timing problem.
Well, it's always been our case that the contract was formed after we had put in our terms and conditions. That's always been our case. The timing point is not a new point. I certainly don't accept that. All I'm saying, in terms of conditional promises, if one can identify, there will be framework agreements, there will be other sorts of agreements where you say, okay, you sign this up, you sign up to this, and I will bring you into the family of potential customers, and I will treat you in a particular way. Now, that could be an exclusivity arrangement, it could be imposing obligations on yourself as to how you will treat particular requests for goods. There could be all sorts of things you can commit to do, but none of that is here.
Yeah, so that the submission is You say Panasonic offered nothing, therefore there was no consideration.
That's right.
I understand.
My lord, then my learned friend says, well, the promise, even if conditional, was subsequently performed and that cures any default. I think that comes back to this timing point. So I don't need to labour that. But then my learned friend says, well, the open offer analysis that I advanced below shows somehow that there was consideration because it was an offer capable of acceptance. In my submission, that's just not right. An offer, the making of an offer, is not the provision of consideration. And of course, if an offer is accepted and there is consideration, there will be a concluded contract. But a counteroffer kills an offer. That's the Butler case. So I say that simply doesn't work. I'm certainly not going to say anything about the legal grounding of the appointment to the Attorney General's A, B and C panels. Something I'm not particularly familiar with. So I don't trespass on that, but in my submission, it cannot, well, either it's different in the sense that there is some statutory backing for it, or there is consideration when one signs up to it, or there are just open offers that are accepted when people do work without making a counteroffer. It doesn't really advance the analysis. So, my lords, unless there's anything else you wish to ask me, those are my submissions in reply.
No. Well, thank you very much indeed, Mr. Kaplan, Mr. Legg, and those that support you. May say so. Well-argued appeal, which we'll obviously take our time to consider, and you will know that the procedure will be that you'll receive our draft judgments in due course for editorial corrections only, together with, please, an agreed draft order, or to the extent that you can't agree a draft order, short submissions about any matters that are an issue between you. The likelihood, I think, is that the judgments will be handed down electronically in accordance with the current practice, but even if they're handed down in court, there'll be no need for anybody to attend for that purpose. Unless there are any other matters, that concludes the hearing. Thank you.